Okay, so people are still filing in, but I'll make a couple of quick announcements. Good morning, everybody. My name is Rachel Hasna. I am with UNM's Division for Community Behavioral Health. Welcome to our Law and Mental Health Didactic. A couple announcements regarding our CEU process. We will be submitting an evaluation link into the chat of your Zoom. If you toggle the bottom menu, you'll see a chat icon. You click that and it'll bring up the chat box. In there, you shall see the eval link within the last 5 minutes of the lecture. Click on that link or copy and paste it into a browser, fill out the evaluation, and a certificate of completion is auto-generated for you. It is your responsibility to save a copy. If you're on your computer, you'll save a copy of the document or PDF. And if you're on your smartphone, you'll want to take a screenshot of the document. If you're joining us by phone, you can send me an email and I'll make sure to get that link to you. We will be emailing a copy of the slides and the recording, the lecture recording link later on this week. And I know that some folks have emailed me regarding being added to the listserv, and I have gotten some emails kicked back. So if you're not hearing from me, I think it's several folks are working for state agencies or organizations that have firewalls. And so if you're not hearing from me, it's not that I'm not responding, it's just our emails are getting kicked back. So send me another email with a different email address and I'll get the information to you that you need. So, and I'll hand it over to Julie.
Thanks, Rachel. Welcome everyone to the University of New Mexico Law and Mental Health Didactic Series. This series is hosted by the University of New Mexico Department of Psychiatry and Behavioral Sciences and the New Mexico Behavioral Health Services Division. We're glad to have you all here to join us today. My name is Julie Brovko. I'm an assistant clinical professor in the Department of Psychiatry and Behavioral Sciences. So first I want to announce that we are accepting applications for our forensic postdoctoral fellowship. We have 2 spots available for the 2021-2022 year, and applications are due on January 14th. We're also really excited to let you know that we were just approved for the 5-year waiver. Next, I want to remind you to join us next week. At that time, we have Deborah Bader, who's going to be presenting developmental issues in juvenile forensic assessment. Now, for our talk today, please ask questions in the Q&A anytime that you feel comfortable, but just know we're probably not going to get to them until the end. Also, we really do try our best to get to as many of your questions as possible, and I ask for you to forgive us if we can't get to yours. Now, for those of you who want your CEUs, but you're on a tight schedule, you do have to stay for that full hour, but you don't have to stay longer than that. I'll try and let you know when that hour has passed, but just know we might stay on a little bit longer to address questions. So now it's time for what we've all been waiting for. I'd like to introduce to our speaker for today, Sarah Desmarais. Dr. Desmarais is a professor of psychology at North Carolina State University. She received her Ph.D. from the Law and Forensic Psychology program at Simon Fraser University and completed postdoctoral training in population and public health at University of British Columbia. Dr. Desmarais' research examines the assessment and treatment of risks and needs associated with clinical behavior, violence, and terrorism. She has more than 120 peer-reviewed publications in journals that include Law and Human Behavior, Criminal Justice and Behavior, and American Journal of Public Health. She's held more than $9 million in research grants and contracts as well. Dr. Desmarais conducts trainings worldwide on risk and needs assessment and serves on local, state, and federal policy task forces. Her work has been featured in media outlets such as the Washington Post, Last Week Tonight with John Oliver, and The Atlantic. Dr. Desmarais, on behalf of the University of New Mexico, the Department of Psychiatry and Behavioral Sciences, and New Mexico's Behavioral Health Services Division, I'd like to welcome you and thank you for presenting today. We're so grateful for your time and expertise, and I'm now going to turn it over to you.
Great. Thank you so much, Julie. And thank you, everyone, for joining us this afternoon or whatever time it is where you happen to be. I think it's incredible that we're able to use this platform to connect to so many folks. I'm really excited to be here. I'm going to be talking on a topic that has been, I don't know if I would say near and dear to my heart, but definitely something that I have been looking at and thinking about and doing research around for the last several years. It's also something that we're hearing about in the news, almost constantly at this point. And so I do want to cover sort of the science and also the practical implications of it, and then hopefully have time for as many questions as we can handle. So I'm going to be focusing on pretrial risk assessment in the context of bail reform. And I'm going to try to do that in a way that makes it most relevant to this group, while also acknowledging that, in fact, it is a bit of a departure from what we all might typically think of when we think of risk assessment or forensic assessment. So I hope to make some of those distinctions clear as we move further through the presentation. First, in terms of disclosures, I want to disclose that I don't have any financial relationship to this program. And then, of course, a disclaimer that this is my presentation and the views expressed herein are my own. They don't represent any views, policies, or positions of the University of New Mexico. So in terms of my learning objectives for today, the first thing I want to do is actually take a step back and talk about bail reform in the United States, and really anchor our discussion of risk assessment in this context. And this is something that personally I didn't have a background in. I got pulled into conversations about pretrial risk assessment without really understanding what was happening in bail reform as a larger kind of process and initiative nationwide and also internationally. So I'm going to start there. I'm going to anchor it within the US context for now. But certainly am open to questions and discussion of how that might look differently in different countries. I'm going to then hopefully take you through enough information that you're able to understand, identify, and describe 3 or more different pretrial risk assessment instruments. And I want to be clear here that I'm going to be focusing on instruments that were specifically designed for this idea of pretrial decision making. So this specific time frame. And again, I'll talk a little bit more about what that actually is. And then finally, I'm going to talk about some research that I've been involved with and that we've led looking at predictive validity of pretrial risk assessment instruments, but then I'm also going to borrow heavily from colleagues and others in the field who have looked at the impact of these instruments and on decision making, and again, in the context of bail reform specifically. So without further ado, I'm going to start with a bit of a history lesson here. So what has happened in bail reform in the United States? And as the sort of subheading there might suggest, we're really seeing a cyclical process that is happening over time, or a pendulum swinging back and forth. So we're at the point where I think, as I hope you'll see through the presentation, we're really in a process of repeating ourselves in terms of what we're trying to do. I would be very remiss at this point to not acknowledge my postdoc, Samantha Zatola, and also my PhD student, Sarah DeHart-Clark, who have been instrumental in helping me with the work on bail reform and also the work that we're going to look at on predictive validity later in this presentation. So I wanted to start with what is bail. First of all, bail is a practice of using money or property as an assurance, and the assurance we'll come to in a minute. But these are decisions and amounts around bail that are informed by local, state, and federal laws or policies. We'll talk a little bit more about what that might mean in a few minutes. I think it's really critical for everyone to understand that the decisions around bail are usually made in 2 to 3 minutes. This is not a drawn-out decision-making process. These are decisions that usually happen either at the front or back door of a jail, when an individual might come in front of the magistrate for initial detention decisions. So when the person is arrested, they're brought to the jail. And at that point in time, a magistrate usually has just a few minutes to decide what they're going to do. If that individual is held, then what we might see is a decision at first appearance court, which is by name, the first appearance that this individual is making in court. And again, this is going to be a decision that now a judge is making, usually within 2 to 3 minutes. And that's not just my estimate, that's actually what the research says. So these are very, very quick decisions, very, very quick hearings with very, very limited information. So just taking that in, just understanding the context and the reality of the bail decision-making helps you think through and maybe appreciate why this is a point of decision and an area of work that is so contentious and that also is open to lots of issues and problems. So coming back to bail here, the idea with bail, this notion of assurance, was to ensure that people charged with a crime appear in court for their pretrial hearings and also their trial proceedings. So essentially making sure that that person shows up in court without committing new criminal acts. So those are the two outcomes that we're going to keep talking about through the rest of this presentation. The two things that usually we're talking about forecasting in the context of pretrial risk assessment is appearance in court and this idea of new criminal activity, or hopefully no new criminal activity, not forevermore, just during this period of time. Okay, so we're not looking at forecasting recidivism over the next 2 to 5 to 10 years. What we're looking at is making sure that people show up in court for their court case and that they don't incur new criminal charges during that period. This is very explicitly not supposed to be a strategy for A, detention, or B, punishment. So we are not right now looking at bail as a way of holding people pre-trial, or we should not be doing that. And we're also not looking to engage in any sort of punishment for the alleged act. Now, why? Because it is still an alleged act. This is the point of period in the criminal justice processing that the defendants are presumed innocent. So everybody at this time is still technically innocent in the eyes of the law. Now, here is another reason why this period of time and these decisions are so fraught and so controversial. All right, so understanding that bail is really supposed to be a strategy to ensure people show up and that they're not committing new crime during their existing trial. What do we know? We know that there is a very negative cumulative impact of bail on criminal justice proceedings, case outcomes, and most importantly for the individual. We know that individuals who achieve a bail amount, whether it's high or not, that they cannot pay, are more likely to be held pre-trial. And I say that that is high or not because even a small amount of bail might be something that an individual cannot pay, and as a result they're detained, or it could be a very large amount that they still cannot pay and that's why they're detained. So whatever the strategy or the bail amount, we know that if they can't pay bail, they're going to be held in jail pre-trial or in a detention center. If an individual is held pre-trial, we know that they are more likely to take a guilty plea. We also know that even without taking a guilty plea, they're more likely to receive a guilty verdict, so to be convicted. And if they're more likely to take the plea and be convicted, they're also more likely to receive a carceral sentence, meaning that they're more likely to receive a sentence to incarceration than somebody who was able to pay their bail and stay in the community. And then ultimately, because of these cumulative factors, we're seeing that people are also more likely to recidivate over time after this particular case. There's lots of other negative cumulative impacts that we could talk about that are outside of the criminal justice system. So we know that there are many factors that contribute to their likelihood of recidivism. So for example, they're more likely to lose their housing in the community, to lose their employment, to have negative family and relationship impacts. So really this initial decision, this kickstarts a series of events that can be devastating for an individual and their family. So recognizing these issues was the first real kind of modern day bail reform. And this was the Bail Act of 1966. And here we saw a movement, away, not toward monetary bail, because there was a recognition of a gap between those who could and could not pay. So we were starting to see more and more that individuals who couldn't pay bail were less or more and more likely to experience those negative impacts that we just talked about. And this was really like the emergence of research on pretrial behavior and practices and consequences. So during this time, along with a lot of other civil rights movement and reform in the United States, we saw the Bail Act of 1966 that had two main aims. The first was to reduce pretrial detention overall, because people who were not able to make bail were being detained more, and we were seeing rates of detention increasing. We also saw specifically research showing income discrimination in the pretrial detention process, right? So here, really what we're starting to see is that detention was more a factor of who had more money as opposed to related to other legally relevant issues. So at the time, and this is the quote from President Lyndon Johnson when he was signing the Bail Act of 1906 into place. He said, "The defendant with means can afford to pay bail. He can afford to buy his freedom, but the poorer defendant cannot pay the price. He languishes in jail weeks, months, and perhaps even years before trial. He does not stay in jail because he is guilty. He does not stay in jail because he is any more likely to flee before trial. He stays in jail for one reason only. He stays in jail because he is poor." So what's amazing, and I mean that in the real sense of the word amazing about this, is that you could say this today. These are the same things that we're hearing in the news rightfully by advocates, by others arguing against the money bail system. So 1966, we see the Bail Act trying to right some of the issues, right the wrongs, if you will, around monetary bail, moving away from monetary bail to other strategies. Fast forward 20 years and we see the Bail Act of 1984. This is the next major piece of reform around bail in the United States. And this really coincides with the era of tough on crime politics. So as you can imagine, the idea is no longer about moving away from monetary bail and reducing pretrial detention. Instead, this particular Bail Act expanded the reasons that were allowable for detention. And very relevant to our discussion today and to the field more generally is that here we saw for the first time it put into act that you could consider dangerousness. So remember, these are individuals who are still innocent, have not been found guilty, and we're now allowed to consider as part of the pretrial decision-making whether or not they are a danger to the community. So that was now a new reason introduced. They also expanded the conditions that could be imposed. So in addition to pretrial detention, we now started to see the use of more and more community-based conditions or other types of conditions as part of pretrial services, or pretrial monitoring really is more accurate. So then, not surprisingly, after this Bail Act of 1984, we see an increase in pretrial detention. So where does that leave us today? We've seen a steady increase in the use and amount of bail, and that is going to become really important later on. So a steady increase in the use and amount of bail since the early 80s. Recent estimates show that the total annual cost of pretrial beds in the United States is $13 billion. So we are spending taxpayer money, $13 billion to hold individuals who are still innocent in the eyes of the law. We're also seeing incredibly disparate impact or disproportionate impact for certain groups. So people are doing a lot of research around this and have so for the last maybe 10, 15 years, showing that we are seeing that Black people, people with serious mental illnesses, other people of color, people with lower incomes, these are the individuals that are being detained more and more, and it's largely a function, as President Lyndon Johnson said, of their ability to pay for the bail as opposed to anything really to do with legally relevant information. So now we're seeing a wave of bail reform passing through the United States again, and this is really what we refer to as the third wave. And there's two broad aims, and they're pretty much the same thing that we were trying to do in 1966. The first one is to reduce rates of pretrial detention. And the second one differs ever so slightly, expanding the focus from just income to more generally thinking about increasing equity in bail determinations or in pretrial decision-making in the absence of bail determinations. So how are we doing this? Generally speaking, we're seeing three broad strategies that might fall under bail reform efforts currently. We're seeing movements away from monetary bail altogether. And there's been some very well covered or at least well discussed examples of this, where entire states or jurisdictions are eliminating monetary bail or talking about eliminating monetary bail. We're also looking at efforts that are addressing this idea of failure to appear. So how we conceptualize, how we measure, and even what we consider failure to appear. So just one very quick example there is failure to appear just anytime someone doesn't show up in court. So there could be a lot of reasons why somebody doesn't show up in court. In fact, we've worked with jurisdictions where the reason somebody didn't show up in court was because they were across the street in the detention center. So it's not like they were willfully skipping their court date. It's that they literally couldn't get to the courtroom across the street because they were being detained on the other side of the building. So other examples could be individuals making decisions about whether they show up for work or whether they go to court, and trying to weigh and consider the consequences of one versus the other. Sometimes we're seeing people fail to appear for court because they didn't even know they had the court date. This information is surprisingly difficult to find in terms of your court dates. So there's a lot of work being done on how do we more adequately understand and address failure to appear. And then there's also efforts to provide services and supervision that might support success during the pretrial period, both in terms of showing up to court dates and also in terms of not committing new criminal activity. So those are three broad areas that we're seeing reform. Now, a thread, though, that ties through all three of these is really that we're talking about strategies that require some understanding of who is at risk of what and why. And that information is the kind of information that we need to actually inform these decisions and services that are happening. Now recall that these decisions that are happening in bail determinations and pretrial hearings are going to happen in 2 to 3 minutes. So there needs to be some strategy to put this information together on somebody who probably just showed up at the jail or was arrested less than 24 hours ago, because a lot of jurisdictions have rules about how quickly somebody needs to show up in court for their pretrial hearing from a due process point of view and being expeditious in case processing. So again, we just need to have a lot of information, and we have to be able to consolidate it in some way so that a judge or a magistrate has enough information and in 2 to 3 minutes makes a decision. So what do we know about what's happening? Generally speaking, we know that every state in the US in the last 8 years or so has enacted some type of bail reform. So this is happening everywhere. About 2/3 of the states that were surveyed in this particular study were using pretrial risk assessment instruments in the process of bail reform. It does not mean that the pretrial risk assessment instrument was the reform. It just means that it was being used in some way. And importantly, what I'm going to assert and what many of us have been talking about is that the use of pretrial risk assessment instruments are intended to inform, but not replace, any of the judicial discretion and decision-making in this process. So another way about thinking through the role that risk assessment might play in this process is that it is one tool in the toolkit. These are incredibly complex problems and challenging decisions in which there is a lot of different things and a lot of different factors at play. And so what I see and what I'm going to talk about is pretrial risk assessment as being one of many strategies that are needed to successfully reform bail. All right, so that's some of the background. Now you know everything you need to know about bail reform in the US. I'm going to talk a very little bit about just the risk assessment instruments themselves, because they do look very different, or in some ways are very different from risk assessment in other contexts. So here, pretrial risk assessment instruments, the purpose is to increase the structure, consistency, transparency, and accuracy in evaluating decisions or the likelihood of whether or not somebody will flee the jurisdiction or is a threat or danger to public safety. So the language depends and differs somewhat depending on the jurisdiction, but those are the two general ideas that we need to be looking at: fleeing the jurisdiction and danger or threat to public safety. So in the sense that all risk assessment tools really come from this idea of wanting to increase structure, consistency, transparency, and accuracy, they're similar in that way, but the actual outcomes are different, right? So we're now looking at two specific outcomes. The other thing is that we're looking at this idea of during the pretrial period. So this is complicated because everybody's pretrial period is going to be different, because all the things that affect how long a case takes to go from initiation to resolution, whether that is that the case is not pursued further, or whether that's all the way to the point of adjudication and conviction, that differs by individual and by all sorts of different factors. So it's messy. This idea of the pretrial period is necessarily messy and necessarily unique to the individual. But like all other areas of risk assessment, it's going to be through a consideration of items that are empirically related to those outcomes. So I'll talk a little bit more about what these tools look like. There are many different instruments used across the United States. I have done a systematic review and meta-analysis of the tools here, and I wanted to just highlight some of the ones that we know are being used in multiple jurisdictions. So the Compass Pretrial Risk Scale, the Colorado Pretrial Risk Assessment, the Connecticut Pretrial Decision-Making Tool, the Ohio Risk Assessment System has a pretrial-specific tool, the federal pretrial risk assessment, the public safety assessment, the VERA point scale, which is, as far as I know, the original that came out of the bail reform of the 1960s. And then finally, the Virginia pretrial risk assessment instrument. So these are some of the most widely used, but there are many, many more. So there's at least 30 more that we've identified just through our research and talking to folks that we know are out there. But this list is the ones that seem to be showing up in at least, statewide or more than one jurisdiction. For those of you interested, I would say that the public safety assessment is probably the one that's being used most widely, with the VPRE, the Virginia tool, and the Ohio risk assessment system, and the Compass tool not far behind. So what do these instruments look like? Generally speaking, they're short. They're really short. And that makes sense, right? Because we have 2 to 3 minutes to make a decision. So here we're seeing somewhere from 7 to 14 items. Most of the tools are providing separate scores or risk estimates for failure to appear and for new criminal activity, meaning that they're using usually the same items in different ways to produce 2 separate scores or risk levels. Not all of them do that, but some of them do that. Across the tools, like risk assessment and other areas, we see different definitions of what the outcomes are. So they define criminal activity and they define failure to appear in different ways. And then only 2 of the tools produce estimates specifically for violent crime. And this is actually pretty important because the standards speak to danger to the public, and that is typically depend on the state defined in some manner of a violent criminal act, usually a violent felony. So this idea of being able to have an estimate for violent crime specifically is very important. All of the pretrial instruments of which I'm aware that are widely used use an algorithmic or actuarial approach, meaning that each of the items are scored, they receive a numerical score, and then these are combined through some method of summing or weighting and putting them together in a mathematical model, a statistical model, to produce a probability or risk estimate. So if some of you are familiar with risk assessment in other domains, we do see other strategies such as structured professional judgment. And so far, that hasn't taken off in the area of pretrial risk assessment. And again, we can talk a little bit more about that, but remember that these pretrial hearings often need to happen within 24 to 72 hours of an individual's arrest. And when the information gets presented in court, they usually only have 2 to 3 minutes. So I'm actually seeing and thinking about what we see as pretrial risk assessment much more akin to risk screening than risk assessment. And we make that distinction in other contexts of risk assessment, where risk screening, the whole purpose is really to screen out people who we don't think are at heightened risk, and then to move into a more in-depth evaluation of that group that remains. In the same way, these risk assessment tools are really quick and kind of designed in such a way that they might screen out folks. But ideally, we would want to see a more in-depth evaluation done after that to speak more accurately and precisely to both why individuals might be at risk, and what that risk is. So what do we see in terms of the content? I wanted to give you just some ideas of what these tools look like here. And I'm going to actually show an example of a tool in a few minutes. So across all the tools, heavy emphasis on risk factors. Not many of the tools are looking at protective factors. In fact, the VERA, which is really largely out of date and almost rarely used anymore, it did include some protective factors, and same with the kinetic hit tool, but the other ones don't include protective factors. They all do include some combination of static, so unchangeable historical factors, and dynamic, so changeable factors that might support intervention or be informing intervention. But really, if I'm being honest here, it's a very heavy emphasis on static factors. I thought it would be interesting to look at the content domains as well. And all of this information is available in our systematic review. So if you don't catch it now, there's more reading that you can do on that. But the inclusion of demographic characteristics is very mixed across the instruments. So I've highlighted there in purple for you all to see which instruments did and did not include any demographic information. So you can see, for example, the ORAS pretrial tool and the VPRE don't include any information on age, marital status, or education versus some of the other tools. Most of them do include some information on personal or social characteristics. And then, you know, most of these tools also include some information on what we might consider to be clinical characteristics, so substance use, mental health, or other antisocial behaviors or attitudes. That sort of white column you can see under the PSA really is signaling something I haven't explicitly said yet. All of these tools, except for the PSA, require an interview. The PSA is a tool that was specifically designed to be filled out with information from file. So as a strategy to expedite the completion of these tools based on records that would be available. Whereas again, as I said, these other tools do require some contact or information about the individual through interview. All of the tools include items on criminal history, which is not surprising given the context, and it really differs in terms of how that is defined in different tools. I would point out, and we'll get to this in a few minutes, there's been a lot of discussion of inclusion of arrest information versus conviction information. Most of the tools actually focus on convictions. They don't, there's very few tools that includes information on just, with air quotes, just prior arrests. And then all but a couple of tools include information on the current case or the current charges. And, you know, not to get into that too deep because I was not involved in their development, but my understanding from talking with folks is that those tools that didn't include current case information, the idea was that the judges would already be considering that in the decision-making process. So this was not necessary to be included in the pretrial risk assessment, or at least that is the view that I have been told. So I wanted to give you an example of what this looks like. So this is the PSA, the Public Safety Assessment, and this is just screenshots from the internet. So this is all in the public domain. And the PSA has 3 scales: the failure to appear, which is the FTA, the new criminal activity, which is NCA, and the new violent criminal activity scale there. And that last one is actually not a scale, it's a flag, and I'll talk about what that means in a minute. But there, as you can see on the screen, there are a set number of items, 9 items with a couple sub-items, and you use the rating on each of the items to inform each of the scales in a different way. So there's some items that only speak to FTA, some items that are used for new criminal activity, and then some items that are used for the new violent criminal activity flag. So here's the coding. Again, all of this is in the public domain. In fact, all of those tools that I showed you on our previous slides, all of their coding and algorithms are all available in the public domain or by request. So here I wanted to show just what went into each of these scales for the PSA, because again, it is probably the most widely used tool. So they use information on current charge, and you can see that pending charge, meaning a different charge in addition to the current charge. They look at prior conviction and prior FTA, so prior failure to appear. And there's a pretty heavy emphasis on that if you look at what the rating or the number of points are there. So if they have, say, 1 prior FTA in the last 2 years, it gets a 2. And if they have 2 or more FTAs in the last 2 years, they would get a 4. And then moving over to the right-hand side there, you end up with a scaled score from 1 to 6. Now compare that to the criminal activity scale. Here now we're considering a few things, few new pieces of information. Age, we still look at pending charge. We're going to look at prior convictions, but here now it's going to be broken out by misdemeanor versus felony convictions. We again look at prior FTAs within the last 2 years, but now newly we add in prior incarceration as well. So a prior sentence to incarceration, not any detention. It has to be a sentence to incarceration. And again, we go through, rerate the items, and ultimately that gets us to a scaled score. And we'll talk about the application of the scale score in a minute. And then finally, I wanted to show you the new violent criminal activity flag. So this is a flag, it is not a scale. So it's a binary, it's a no versus yes. And again, a few things repeated across the scales that we're seeing. Here now, one of the new things that we look at are the combination of young age and prior or current criminal offense, I should say, and also prior conviction, both overall and violent convictions specifically. So here, instead of having a scaled score, each of the items get rated, and anything that results in a score of 4 or more ends up getting a flag for violence of yes. So something that is perhaps different or more drilled down in the pretrial risk area is that most of these instruments suggest that you don't use just those scores from 1 to 6 to make policy decisions or make individual case decisions, but instead you use something called a release conditions matrix or a praxis, or different language used for different tools. But here the idea is that you're going to crosswalk the scores on the PSA for the new criminal activity score with the likelihood of failure to appear score. And this very explicitly in their manual and in their guidance online says that it's used to determine release. So it should not be used to determine detention. And I'll show you an example of that in a minute. They also say that this should be expressed as a likelihood of success and not a likelihood of failure, which is a twist or a departure from what we see in other areas of risk assessment typically. And the last thing is that they say this should be developed locally. So these are more policy, local jurisdiction decisions than being decisions anchored in some sort of national norming or anything like that. So the ways in which the results of the risk assessment are being used should be informed locally through a process of discussion across all sorts of stakeholders. And they have some guidance online about how to do that. They also actually do provide technical assistance to jurisdictions who qualify. So what does this really look like? Because on here, I'm just saying release, or they're saying release levels 1 through 3. So I've borrowed an example from Mecklenburg, North Carolina. So that's Charlotte, North Carolina. And this is available, again, in the public domain on the county government website. So I'll walk you through it just because I know some of this is a little hard to see with the colors. So at the very top of there, you'll see that the release or detention eligibility is made prior to considering the risk assessment decisions. And those are actually a function of largely the charges. So they make initial decisions around who is eligible for release as a function of charges and perhaps some other factors before they then look to this risk assessment result and the matrix to inform what the release might look like. So assuming it's a charge that would qualify for release, they then look here to crosswalk the score. And a couple of things I wanted to point out, and this is very common in the field of pretrial risk assessment, those rates of success are incredibly high. So these are numbers based on local study, local validation, where they say somebody has a risk level of 1, 91% of those people had no new criminal activity. Now 6 was the highest score you could get. And even then, still about half of all of the people that were evaluated in this study who received a score of 6 were still remaining crime-free during the pretrial period. So one of the things that we're seeing here is actually a high rate of success and a movement away from using language of low, moderate, or high risk. So we're framing things in terms of success. The other thing that we're seeing here, again, similarly, is even at the highest rate of risk, according to this tool, at the highest score on the FTA scale, that still almost 2/3 appeared in court. So overall, we're seeing that there are generally very positive outcomes during the pretrial period, which I think is a really important takeaway for anyone thinking about this or even talking about this in their own work. So then what they would do is crosswalk the two scores and use this as guidance as to what kind of decision somebody might receive. So somebody who got a 2 on the new criminal activity scale and a 2 on the FTA scale here would qualify for a written promise to appear, so essentially release without conditions. And somebody then moving further up, and they've color coded it for ease of use, basically, all the way up to here, receiving both the highest score on FTA and the highest score on NCA. They're still getting recommended release, but this time with intensive services during the pretrial period. And what that might look like is going to be very jurisdiction specific. So whether that's supervision, whether that might be electronic monitoring or other conditions, I don't know. But the idea here is that those people are still eligible for release. Okay, so just wanted to give you that example to share maybe some ways in which these differ or depart from risk assessment in other domains. So now I'm going to tell you about how they work, or what we know about how they work. So first of all, this is a topic that I receive a lot of emails and a lot of phone calls about. There's a lot of coverage in the media that pretrial risk assessment is unable to predict outcomes, it's racially biased, and it's increasing detention rates. So I'm going to give you just a few examples of some of these headlines. So the first really, I think, important statement in this area that came out was the shared statement of civil rights concerns. Over 100 agencies have signed onto this, saying their concern about risk assessment, really echoing these three concerns and stating some conditions under which, and the only conditions under which risk assessment would be appropriate. Other coverage, the Marshall Project released a paper entitled, "Can Racist Algorithms Be Fixed?" So they're implicit in that headline is that these algorithms, these pretrial risk assessments are racist. The Philly Inquirer, Pennsylvania's proposed risk assessment tool is racist. The Boston Globe, discrimination in the age of algorithms. The New York Times, the problems with risk assessment tools. And then most recently, the Pretrial Justice Institute came out with a statement saying, with a big red do not enter circle, abolish risk assessment. And in that statement and in that report, as they call it, they conclude that risk assessment instruments simply add a veneer of scientific objectivity and mathematical precision to what are really very weak guesses about the future. So here they are questioning and asserting that risk assessment in the context of pretrial is not possible. They're saying that there is no validity to these predictions. So what do we know? So me and my research team, we sought to do a systematic review of the empirical evidence. We were focused on validity, and we were looking at specifically validity in relation to failure to appear, new crime, and new violent crime specifically. We wanted to look overall across individuals assessed, and then also, if possible, by subgroups defined by gender and race or ethnicity. I won't bore you with the details. We went through a very standard approach to a systematic review, and we followed the PRISMA guidelines and searched by instrument names and acronyms. We went through all of the databases we could think of and included both the white and gray literature. So we also did broad Google searches, to the nightmare or the horror of my graduate students. And then we specifically focused on tools that were studies that evaluated validity in predicting pretrial outcomes. And that actually was important because some of these studies ended up looking at outcomes outside of the pretrial period, which is a misapplication of the tools. We looked specifically at those being conducted in the United States, peer-reviewed journals, as you can see there, a whole host of different outlets. And they had to have been produced by December 31st, 2018, because we did this review last January. All right, so here is just a flow chart of our process. I'll share the most important pieces. First, we started out with almost 33,000 records. We ended up with 13. So through a process of elimination and identification of other sources, this is what we end up in terms of our eligible studies that reported all the things that we needed in order to do this systematic review. So for each outcome, we examined predictive validity for the total scores or subscale scores for the produced risk levels, and we used proportional odds ratios for those, which in all cases we needed to calculate for the purpose of the study. And then when there was more than one estimate in a given study for a given outcome, for a given scale or predictor, we then used an average estimated random effects model to get the estimate across those multiple reports. That left us with 6 instruments that we could look at. And I'm going to just touch on a very high level summary of the studies and of the findings. One thing that's different, I think, in pretrial risk assessment research compared to other domains of research in the field is that we had huge sample sizes. So the smallest sample was 452, all the way up to 500 some thousand. So the mean sample size across these validation studies was 55,000 or so. Not surprisingly, many of the studies, or most of the studies, were conducted by people who had developed the tool. This is a surprisingly young field in terms of the research. This has really been ramping up in the last few years, with the exception of the Vera and the vPray, some of the older tools, I should say. Most of these studies are fairly recent. And even actually, since we've done this review, a few more studies have come out. And we were able to look at outcomes by gender and race or subgroup for 3 instruments: the PSA, the Federal Pretrial, the PCRA, and the vPray, the Virginia Pretrial Risk Assessment. I'm not going to go into a whole lot of numbers. I just wanted to highlight some group difference stuff and some overall results. So first, we actually saw fair to excellent association. So the AUCs ranged from 0.64 to 0.73. We saw risk levels with fair to excellent agreement as well. So the proportional odds ratios were anywhere from 2.267 to 5. We saw very few differences by gender, and they were almost negligible. I'll show you an example in a minute, and they were not in a consistent direction. So sometimes we saw better predictive validity, even if it was by a very small amount. We saw better predictive validity for men than for women, and sometimes we saw it in the other direction. There were some differences by race and ethnicity, but again, not as many as we anticipated maybe. And the pattern tended to be lower levels of predictive validity for people of color. I should say that we had to collapse across race ethnicity groups and use this people of color category, which of course is not ideal, but it reflects our inability to aggregate across studies in any other way. And I would just say that this pattern showed itself, but again, the differences were quite small and still not always in the same direction. I'll show you an example. So I'm going to just zone in on new violent crime, arguably the most important outcome in this context. And so for here, we could look at the PSA and the Federal Pretrial Risk Assessment. And you can see that the numbers for men and women were very close, 0.65, roughly 0.66 versus 0.69 and 0.66 again. And then here we see some slightly higher AUCs for white people than for people of color. But again, the difference is quite small. So if you look at the Federal Pretrial there, the difference is 0.68 versus 0.67. So what that really means in terms of kind of a practical significance is something that we could talk about a bit more. Then looking at the risk scores, again, we're seeing some slight differences, but not in any like very compelling pattern that suggests that there really is bias in one direction or another. So for the PSA, we saw slightly better predictive validity for women than for men, but then when we went to the PCRA, it was in the reverse direction. Then when we look at the PSA for white people versus people of color, we see better predictive validity for white people. And if we look then at the PTRA, the pattern's reversed. So it's really not some sort of compelling overarching pattern in one direction or another. So moving into what is arguably more important, how are these tools impacting pretrial decisions? And here, again, I would just throw out the caveat that this is not my own work. This is my summary and understanding of really important and rigorous work completed by others. So what do we know so far? As is the case in most areas of risk assessment, we have not done enough studies on impact. More research is needed. But several recent studies show decreases, statistically significant decreases in pretrial detention rates in decisions that use pretrial risk assessment results compared to decisions that do not use risk assessment results. So there have been some recent studies that are really well done where we're looking at multi-site comparisons and propensity score matching and all the like that are showing decreases in pretrial detention rates very consistently and statistically significantly associated with the use of pretrial risk assessments. So suggesting that they're actually helping to achieve that bail reform goal of decarceration. We see this overall, and we also see the same level of decreases across groups defined by race and ethnicity. So that, I think, is also a really important finding, that this is not just something that we're seeing rates of detention decreasing for white people, but we're actually seeing it across groups defined by race and ethnicity. And then the most important and interesting finding here is that we are seeing these impacts, these differences in pretrial detention rates, even when there are some differences in the level of predictive validity. So what does that mean? Remember on a previous slide, I showed you that for some of those groups, for men, for women, sometimes there were slight differences in the AUCs. And for white people and people of color, there also were some differences in the AUCs or in the proportional odds ratios. Well, what we're seeing in a few studies now is that even if there are slight differences in how accurate they seem to be accurate enough that they're informing decisions that ultimately lead to the same level of decrease in pretrial detention rates. So some final thoughts. Compared to what? One of the things I talk about a lot in the context of risk assessment, whether it's pretrial or otherwise, is that the comparison against which we hold pretrial risk assessment, whether it be in terms of predictive validity or in terms of, more importantly, impact on decisions, is not compared to perfect prediction or perfect changes in decision making. It's compared to what is currently happening. So what is currently happening? Unaided human judgment. What do we know? Accuracy, it's often limited. We have been doing research in this area for over 60 years, and we know that the human judgment can be have very limited accuracy. We know, based on several meta-analyses, ours is just the most recent one, that pretrial risk assessment has pretty good accuracy in terms of predictive validity, which is in contrast to what some of the critics and advocacy groups have said. What do we know about transparency? We know that unaided human judgment, as humans, we have very limited insight actually into how and why we're making decisions, and it's very difficult to articulate to people. What do we have with pretrial risk assessment instruments? All of the items, scoring, weighting, and algorithms for those tools that I showed you are actually all available. Even the Compass, which has had a lot of attention around it, they ultimately did release and make their algorithms and their scoring available. Consistency. We know as humans, unaided human judgment often has limited consistency. Pretrial risk assessment tools are going to be much more consistent in terms of the items and the scoring of that and how it informs risk levels. And then finally, fairness. I think this is really at the crux of the most important issue here. We know that bail decisions are incredibly biased against marginalized and minoritized groups. And the status quo, the idea of staying the course with unaided human judgment in this context, in my view, is just not the right thing to do, because we have, again, decades of research showing biases in these decisions, specifically against the groups we'd be most concerned about, against Black people, Hispanic and Latinx individuals, people with lower incomes. It just goes on. And so we know that there's a problem. Is risk assessment a solution? I don't think it is a solution. I think it's part of the solution, because we are seeing very limited evidence that this is making things worse. In fact, we're not seeing that in any study. What we are seeing, that it is helping to improve or reduce detention rates. So criminal justice involvement is also always going to be considered in pretrial decisions until such time that there is such major and meaningful transformation in the pretrial decision process. This is going to happen with or without risk assessment. state law and bail schedules require some consideration of current charges, criminal history, prior failures to appear, and ties to the community. Those are things that exist in law that judges and magistrates are going to be considering. So do we want them to be considering it with the aid of a structured risk assessment tool, or just in the absence of any supports or structures and left to unaided human judgment? I wanted to give you a case example. New York State has received a lot of attention for its effort to eliminate monetary bail. That went into effect earlier last year, actually before that, I think it was January, about a year ago now. And then there was a whole lot of attention to this initiative and this reform, and a lot of media attention focused on a handful, in fact, 1 or 2 cases where there was evidence that somebody from New York State fled to Florida, for example, during the pretrial period. And that got just a lot of news coverage in New York State, and I think it also happened nationally. What happened in the later in the year, in the rollbacks in around July, as indicated on this chart, we see that they actually rolled back that entire reform effort. So they eliminated bail reform, and then as a function of public pressure, political pressure, they rolled back a lot of those changes. And now what do we see? We see that every day there are 1,500 more people detained in New York State than even before they implemented this bail reform. So this is, first of all, I want to credit, I did not make this figure. This is a figure Katie Schaefer made that I pulled from Twitter, and the source data there is the Criminal Justice Commission of New York. So I just wanted to give the acknowledgement where it's due. But what this really drives home is that the idea of returning to status quo, or returning to unaided judgment, returning to bail as it stands, is not the solution if we're looking to reduce detention and increase equity in this system. So what is the conclusion? For me, where I stand currently on this is well articulated by the Partnership on AI, and they said risk assessment tools may not achieve a defined notion of fairness, but rather be comparatively better than the status quo. So another way to think about that is they're probably a step in the right direction. Are they the solution? No, but they can help either in the interim or in the process of achieving those aims of bail reform. So very quickly, just wanted to share here my references. Obviously, I'm happy to share any of these literature or other things that I cite in the presentation. And with that, I can open it up for questions.
Thank you so much. I want to let everybody know that's on right now, the link to the CEU survey has been posted or should be posted in just a minute. Please remember, you need to print your own copy or save your own copy. We do not email those out to you. We don't keep copies of them. So take a screenshot, print it, save it, whatever you need to do. All right, so the first question is the items that you just mentioned that could lead to potential bias, could those items be removed while preserving the validity of the tool? Maybe remove race, remove gender, or use other variables to see if it's valid without those pieces of information?
Sure, I should point out none of the tools include race or gender. So none of those tools include those as items. The concerns that most have are around criminal history. And so I'm not aware of any study where they have done the risk assessments completely without those items included. I think it would be very challenging. If you think about the public safety assessment, for example, if we took out information on criminal history, we'd be left with almost no items. So it would mean a major overhaul or change in that instrument. A colleague of mine at Duke University, Cynthia Redden, has done an analysis looking at what are the best predictors using the compass items out of the ProPublica investigation in Broward County, Florida. There, she happened to find that with only age and criminal history, she achieved the best prediction. Now, those are probably two of the items we'd want to get rid of the most. So that's not a very useful solution. But the only other thing I would say to that is, well, two things. That's a really great area of study. I support anyone who wants to try to do that research. I think it would be very valuable. And I know of colleagues and I know some folks who are trying to do some of these manipulations to see if it can be done. And except that the judges and the magistrates will still consider criminal history and current charges by law because they're included in statutes and bail schedules. So we would also need to think about how do we support efforts to reform those laws and bail schedules, because they will be thinking about that information no matter what.
Next question is, do you think this topic or this information, this stuff is useful beyond the pretrial stage?
I think that the information or the dialogue that is happening and the debate and the discourse around pretrial risk assessment is pushing the entire field of risk assessment to think more critically about the content of the tools, the transparency of the tools, predictive validity, and bias. So I think that even if folks are not working in the pretrial period, the issues that are being brought up are actually being pushed forward in ways and receiving a lot of attention in ways in this particular area that haven't been happening as much or happened a while ago, in fact, even a long time in other fields of risk assessment that are important to revisit and think about. So there is definitely a lot of differences and very important differences as well as nuanced differences in the context. But still, I think it's important to think about how pretrial risk assessment, risk assessment generally is, what is its role in criminal justice reform and transformation?
The next question is, why include criminal history on pretrial risk assessment? Doesn't the judge already consider that in their decision making, and could this not result in double counting?
That is a great question, and I don't know the answer. When most of these tools were developed, they were looking for the best predictors of the outcome of concern. And I invite you all to look at some of the development work for each of these instruments, whether it's the PSA or the VPRE or the ORAS. But they essentially looked at, statistical associations. They did the traditional kind of actuarial development studies, just trying to identify what are the best predictors of outcomes. And that's what they found. So I think that a way that I would maybe flip that narrative is to consider either what would we consider instead of, or would we eliminate them altogether? Would we make these very super short instruments? Would they still have the predictive validity that would be considered acceptable or even better than acceptable, ideally? And then how are we going to support judges and magistrates and other pretrial decision makers to consider that information in a way that is less likely to be resulting in biased bail determinations? Because that's more, I think, what the question is for me, is how do we reduce bias and increase fairness and equity in these pretrial determinations overall, and whether or not risk assessment is part of that process, will depend on a lot of other factors.
For those of you that need to jump off, it is 1 o'clock, just a couple minutes after, and we'll see you next week. We do have a couple more questions though that we're gonna try to quickly address. So we've got a couple of questions about who these measures are designed to be used by. Is it mental health professionals? Is it probation officers, correction officers, judges? What's our audience here in terms, or user audience?
Yeah, that's a great question. So some of them are designed, so the PSA ideally could be abstracted from records. So it could be filled out and populated automatically. That was part of its design. In practice, it's often pretrial services staff who are usually not mental health professionals, but and their role is more about the administration of pretrial services and does not come with some sort of usually professional distinction associated with that. Sometimes I think in some jurisdictions, magistrates are filling it out, but this is not something that we're seeing typically a mental health professional in the way that we would expect, say, for example, with risk assessment in other contexts or forensic assessment more generally. So those questions about substance use and mental health, when they're included, are going to be usually very basic self-report or record-based pieces of information. So, have you ever had a substance use problem? Or, have you ever been hospitalized for psychiatric reasons? So they're not going to be in-depth evaluations in the way that we might expect in other areas of risk assessment. And that's why for me, I see these really much more like screening instruments that ideally would be followed with a more in-depth evaluation.
And that leads us to our final question. This individual is asking if you would ever recommend a psychiatric evaluation for these types of issues.
That's a really great question. I don't know that the research is super compelling that serious mental illness is a causal factor for failure to appear in court or for new criminal activity, specifically during the pretrial period. So I would think of it in the same way that I think of mental health as it relates to violence. So for some people, it might be related to their crime and their failure to appear, but there's a whole lot of reasons why people may or may not show up in court. The other thing to remember here is that the context, right? So these would have to be very quickly done, and legally they typically have to be done within 24 to 72 hours. And 72 hours is usually to allow for a weekend when no evaluation and court hearings can happen. And so I don't know that I think it's practical or relevant. Another question that is really being debated that I didn't get into at all in this presentation is whether or not there really is a legal authority to require any conditions beyond those that would specifically relate to appearing in court and new criminal activity. And that's a slippery slope of thinking through identification of needs that might move beyond the scope of the current legal question.
All right, thank you so much for your time today. This was fantastic.
Thank you very much for having me and for the questions.
Absolutely. Have a wonderful day. For those of you that are still on, we'll be on for about 5 more minutes to allow you to get to that survey, but otherwise we'll see you all next week. Thank you again.
Hey, Anthony, we've had the question or the evaluation link up for a while now, so I think we can just go ahead and conclude for today.
Okay, sounds good.
Thanks so much, Sarah.
Wonderful presentation, Sarah. To your day.
Thank you. Have a great day.
Thank you.